So, if a requester wants copies on paper, the office can only charge for the cost of paper, ink, and toner needed to make those copies. If a requester wants to receive copies on a CD, the office can only charge the cost of the CD. Actual cost depends on the capabilities of a public office. For example, a public office that prints on an inkjet printer may have different actual costs than an office that uses a laser printer. The office may also charge actual costs for any packaging, delivery, or transmission, and may require those costs to be paid in advance. But it is often in a public office's best interest to not charge for copies for at least two reasons. First, invoicing and other collection costs, and second, goodwill. Sometimes it can actually cost a public office more to charge for copies of a public record than to provide the public record without charge. An office could spend more on postage to mail out an invoice for copying costs than it would actually collect if it is only producing a few copies. And, when considering the cost of processing a check for payment fees, a public office could actually lose money by charging and collecting copying costs. A public office may also garner a lot of goodwill by foregoing any charges for public records and giving the requester the public records free of charge. If a public office does decide to waive these costs, it may want to inform the requester that it is doing so as a courtesy. There is no obligation under the Public Records Act to provide free copies to someone who doesn't want to pay or is unable to pay the actual costs. Demonstrating some of the issues that can arise with charges for public records is the following clip, which is an edited portion of a verbatim reenactment deposition from a Supreme Court public records case, State XREL Data Trace Information Services, LLC versus Cuyahoga County Fiscal Officer. You can access the full reenactment on the New York Times website. In this case, records requesters sued to compel the Cuyahoga County Fiscal Officer to provide copies of electronic images of instruments recorded in the recorder's office on CDs at actual cost. The fiscal officer wanted to charge $2 per electronic image of each page under a statute that allowed such charge for photocopying a document. If that charge were actually imposed, the cost of the requested records would have been in excess of $200,000.
During your tenure in the computer department at the recorder's office, has a recorder's office had photocopying machines?
Objection.
Any photocopying machine?
When you say photocopying machine, what do you mean?
Let me be clear. The term photocopying machine is so ambiguous that you can't picture in your mind what a photocopying machine is in an office setting?
I just want to make sure I answer your question correctly.
Have you ever? Do you have machines there where I can put in a paper document, push a button or two, and out will come copies of that paper document also on paper? Do you have such a machine?
Yes, sir.
What do you call that machine?
Xerox.
But the court concluded that copying electronically recorded instruments onto a CD is not photocopying. The court found that the requesters were entitled to copies of the electronic records at actual costs rather than the higher statutory charge for photocopying documents. In this case, the requesters presented evidence that actual cost was no more than $1 per CD, and the public office did not present any evidence to the contrary. The court concluded that the records had to be provided at a charge of $1 per CD. Public offices that charge for copies should be able to document the reasons for specific costs being charged per page. At the Attorney General's office, employees in the Information Technology section were asked to estimate the costs of printing or copying a document onto a page, and these employees determined that 5 cents per page approximated the costs of toner, paper, wear and tear, and maintenance on printers. Public offices may want to consult with employees who are knowledgeable about the specific costs of printing documents in the event the public office would have to justify these costs in court. Delivery of requested records may be made by any available means of delivery or transmission as chosen by the requester. Email is a very popular means of delivery, but there are many other options, including regular mail or hand delivery. A requester can ask to have records transmitted by any method they prefer, by mail, certified mail, or even by courier. However, the public office may require prepayment of postage or other actual delivery costs, as well as the actual cost of supplies used in mailing, delivery, or transmission. We encourage public offices to work with requesters to determine reasonable means of delivery for them. And just a quick note here, if you are working with an anonymous requester, make sure that you have an email address or physical address to actually send records to them. If a requester does not want to provide address information, remember that they can choose really any option to have the requested records delivered. In the case of a very reticent requester, having a proxy come into your office to pick up copies of records might be a good option. Just because a public office is not required to do something under the Public Records Act does not mean that it can't or shouldn't do it. There are many situations where going above and beyond what is required by the law is a win-win situation for both public offices and public records requesters. Is scanning actually easier for your staff than providing the requested paper copies? Then offer it. It saves the office time and can get the records to the requester faster. Would it be easier to create a new list or summary of requested information than to redact lots of unrequested information in existing records? So, what if a public office stands on its rights and denies a request for a list of open cases? They may be facing a follow-up request for the first page of the complaint filed in every open case the public office has. What a nightmare to retrieve and copy those records. At the Attorney General's office, that request would mean thousands of cases. At that point, wouldn't it have been easier and quicker for everyone if you had just created a list of cases? Would billing for 25 cents of copies cost the office more than it gets? Then don't do it. Remember, if your public office chooses to go above and beyond your duties under the law, you may want to let the requester know that you are doing this for them as a courtesy. You are creating your office's reputation for openness and transparency by the choices your public office makes and responding to every request. The Ohio Public Records Act is amended more often than you might think, and the Ohio General Assembly adds, modifies, or removes other statutes that affect the availability of public records with some frequency. The Attorney General's Sunshine Laws Manual is updated annually to keep pace with these changes. And in fact, the General Assembly recently responded to the public's desire for a quicker way of resolving public records lawsuits by enacting an entirely new process for suing a public office in the Ohio Court of Claims. Under this process, a requester who is dissatisfied with a public office's response to a public records request can pay $25 to file a complaint in the Ohio Court of Claims. This process was created to supplement the existing remedy for addressing alleged public records violations by including mandatory mediation and short filing deadlines. In another modification to the law, the General Assembly added new exceptions for specific types of personal information. Another way the General Assembly can impact public records obligations is to take information that would usually not satisfy the definition of a record and tell public offices that they must treat it as a public record. An example of this is Revised Code Section 149.434. That statute requires public offices to maintain a database or list that includes the name and date of birth of all public officials and employees elected to or employed by that public office. And the statute expressly says that the database or list is a public record. Without the statute, employee birthdays likely would not be a record, as they do not document the activities, policies, and procedures of a public office. Another statute, Revised Code Section 307.862, provides that information in a competitive sealed proposal and bid submitted to a county contracting authority becomes a public record only after the contract is awarded. The General Assembly also gave people who are journalists special access to certain records that are not available to other requesters. For example, journalists can see coroner's records that no one except the coroner and the next of kin and insurers can see, including photographs of the decedent, any suicide notes, and the notes and observations of the coroner developing the autopsy reports. Journalists are permitted to inspect these documents, but they are not permitted to copy them. Journalists can also see the actual residential address of peace officers, firefighters, EMTs, and other safety officers identified in that exception. And journalists can see workers' compensation claimants' addresses, telephone numbers, and names of dependents. In order to see this information and copy it in some cases, journalists have to follow special rules when they are requesting these records. Journalists must make the request in writing and must identify themselves with their name, title, and the name and address of their employer. The request must also state that the disclosure of the information sought would be in the public interest. So what is a journalist? The General Assembly defined this term to mean someone who is engaged in any news medium for the purposes of disseminating information for the general public. This definition is very broad and is not limited to a journalist working for a traditional newspaper, and by its definition, likely extends to bloggers and other individuals who engage in any news medium to disseminate information. The Attorney General's Sunshine Law Manual includes a chart outlining the greater access afforded to journalists and other requesters under the Public Records Act. While the General Assembly has given some individuals, like journalists, greater access to certain records, the General Assembly has imposed additional restrictions on prison inmates who are requesting certain types of records. An inmate seeking records concerning his or her criminal investigation or prosecution is first required to obtain approval from the judge who sentenced the inmate to request these records. A public office is not required to produce these records unless the inmate has secured the approval of his or her sentencing judge. But keep in mind, this restriction is limited to when an inmate is seeking records regarding his or her own criminal investigation or prosecution. For all other requests, inmates are just like any other persons. The General Assembly has also modified the rights of some public offices to charge for copying of records. For example, coroners are permitted to charge 25 cents per page, even if that is more than the actual cost that the public office incurs to make copies of the records. The Bureau of Motor Vehicles may charge a fee of $4 for accident reports that is set by statute. Separately, the Bureau of Motor Vehicles may charge $5 for copies of driving records. In a court case challenging this fee, an Ohio trucking company attempted to request an unredacted copy of an employee's driving record for the actual cost of the record. The requester argued that the $5 fee conflicted with the Public Records Act requirement that a public office was only permitted to charge the actual cost of providing a public record. The Ohio Supreme Court held that the specific rule allowing the Bureau to set the procedures for responding to requests took precedence over the general provision that public records be provided at cost.